Okay, I think let's get cracking. Good afternoon, everyone, and welcome. I'm Giorgia Cacace, General Manager at Secure Impact, and I am delighted to be your moderator today. We're talking about something super important, and to help with that, I'm joined by a panel of experts from legal and cybersecurity technical, from global legal business DWF and cybersecurity consultancy DWF. And we'll be discussing the top mistakes that we see businesses making before, during, and after a breach. Now, before we get cracking, a couple of housekeeping items. So first of all, this is a session for you. We would love you to take advantage of the panel of experts with us today. Please do send questions through the chat box and we'll collate them throughout and get back to you at the end of the session. Secondly, the session is being recorded. You'll receive a link to watch to your heart's desire after the session has closed. There are handouts readily available within the dashboard section of your GoToMeeting panel. So that will be under the drop-down handouts section there. And lastly, if you have any technical problems, please don't come to me, but we do have a team in the background that will be willing to help. So please put any issues in the chat box on your dashboard. So let's start. Now, as we're all aware, the digital landscape that we're all existing in changes daily, and it's mired with ever increasing cyber threats, regulatory obligations, and legal requirements. Incidents which are inevitable can be incredibly stressful and high pressure situations. And this is where mistakes are made. Managing these incidents and making these rapid decisions in states of panic means that they are avoidable through good planning and learning. So this is really what we'll be running through today. And there will be valuable tips that are useful for CISOs, for general counsels, for DPOs and more. So on that note, I'll move on to introduce our panel. Starting with James. So James Lyne is unusual in cybersecurity. He's been in offensive, forensics, malware, and taught at the highest levels to some of the most technically challenging cyber operators worldwide. Now, you should listen to him because in his years in this industry, he's been in the middle of so many of the world's largest breaches. He's seen every sin, every success, so he can help you avoid the silly mistakes. James was there in 2004 in global outbreaks that impacted millions of systems. He was there when HMRC lost CDs that led to the establishing of the regulator. He was in the middle of some of the biggest breaches of the last 10 years, stopping the bleeding. So I'm sure he can help us out today. Moving on to, actually, this deserves mention. When I asked James what he was most proud of, he said getting hundreds of thousands of young adults to try cybersecurity to build the next generation. And in his capacity as SANS CTO, having trained thousands of security folks that lead the industry in how to actually keep organizations safe. Moving on to Simon Davis, who's barrister and associate in DWF's London-based cybersecurity and data protection team. Simon is a remarkable barrister and the go-to for regulatory and legal compliance advice. You should listen to him because he's helped out some of the largest companies globally mitigate damage of large-scale breaches, successfully plan their incident response, and navigate regulatory enforcement. Simon has enviable advice to what really matters. He can help you cut through to key actions under a time pressure, and he's also worked with a number of these regulators. Simon has had numerous career-defining moments, but when pushed, he was bound by client confidentiality. He did rather casually mention he has actually written the book on this. So he recently co-authored the book Data Protection and Compliance, published in 2021. I've just checked on Amazon, 14 copies left apparently, so get cracking if it's something that you're interested in. Last but not least, David Barr is Principal Cert Consultant at Secure Impact. Now, I'm delighted to call Dave a colleague. He's an exceptional forensics practitioner. He's a self-confessed super geek. And when I asked him what his proudest moments were, he told me how he's been able to use his forensics and technical skills to put prolific child abuse offenders behind bars. Dave has been on the defensive and proof side of breaches, and you should listen to him because he can tell you how companies or employees accidentally and purposefully scupper evidence, and the nasty risks that of course come with that. So I'm really excited to hear what works and what not to do. So we should have our first poll question coming up in front of you, and while you're answering that, let's kick off. So let's think about before an incident. And James, from a top level, could you please help us out here? What are some of the most common mistakes we should discuss today?
That's a great kind of opening question, and I know there are a lot of different directions we could take this. I think this panel, by the sounds of collective experience, have probably seen way too many sins to describe in this short session. I think if I were to pick the biggest problems that I run into from medium-sized to large-sized organizations, different sectors, different horizontals and verticals, it's the challenge of having the right team assembled for an incident, the right plan in advance, engaging the right stakeholders, and putting it into practice before you're under fire. If you imagine kind of undergoing military training and learning to kind of use a rifle, you wouldn't start by throwing someone into the middle of an active war zone and being like, hey, I hope you can use this thing. A lot of the time, organizations purport to have good processes, good IR. They have what looks like the right team, but they haven't got together and actually run through it and practiced recently. That leads to all kinds of bizarre and horrible situations. I'm reminded of a couple I'll share early to kick us off. One was, it's actually years ago now, working with a bank in the US. And this particular bank did a notification to their customer base that they'd been breached. Someone had managed to gain access to a database that contained substantial amounts of personal and financial information. They sent this notification out, through the kind of marketing and comms team, told all their customers. When they actually managed to bring together the team later, and that was a little bit of a delayed process because one of the instrumental coordinators there to that planned process they had in this business was on holiday. So it was a bit of a scrabble. It actually transpired for fun that the breach in question was a planned pen test. So they basically shot themselves in the foot through their own heads. They notified all their customers they'd been breached, but it was them. I mean, they were literally running responsible tests. And it illustrated beautifully the importance of not just having the right people around the table, but the right checks and balances. When do you notify senior leadership? When you notify PR? How do you make sure your technical facts are straight? And all too many organizations at varying levels of maturity between no plan and I know what I'm doing really don't practice this stuff as frequently as you'd want. That's probably where I'd start us off, as it's the root cause of so many other issues, but a lot more we could and will talk about shortly to get specific on how you avoid these mistakes.
Thanks, James. It's a fascinating example. And on that note, Dave, I'll come to you. If we focus on the before an incident phase for our CISOs and security professionals joining us today, and as someone who deals with the consequences of a lacking IR preparation on a day-to-day basis, what are your top tips that you can share for a robust IR plan?
Well, I'm sure we can all agree that prevention's better than the cure, but today, sadly, it's probably more of a case and instance a matter of when, not if. So I'll list 4 things that are some are specific to plans, some is just general preparation. Firstly, you need to have a plan which is fit for purpose. I mean, too many organizations have a high level plan like just report it to a CISO or call your third-party incident response team. It's better than nothing, but having a plan specific for the most likely instance is going to help at that critical time just after a compromise where you need to act quickly. When something happens, you just want to grab a business email compromise or ransomware plan off the shelf and be able to follow it immediately. You obviously can't prepare for every eventuality, but you can prepare for the more likely scenarios. It's also worth pointing out as well, like policies like which services need to be shut down in certain situations, so they should also be considered and in place. For example, a large hosting company like AWS or Amazon, they're not going to shut down the entirety of Amazon for a small incident, so you need to have considered that. There's no point having a plan if no one knows where it is or how to do a few of the things that you've listed in it. Test the plan. You do it for fire alarms, why not cyber incidents? A lot of documentation I see has like a compliance flavor or a regulatory feel to it. It feels like it wouldn't exist if someone didn't say you had to do it, or to put it another way, it feels like they were made in a hurry 5 years ago and haven't been looked at since. Secondly, I'd say related to the last point, specifically to ransomware, I mean, year on year, there's a massive surge in ransomware attacks. So you need to give it serious thought about what would happen to your organization should it suffer a ransomware attack. Put in place any measures you can to make it less likely to occur, and obviously any kind of make sure you're performing regular backups to offset any damage when it does occur, for example. But ransomware needs to have a specific place, I think, in your plans. Thirdly, a lot of cyber incidents are caused or enabled by human error. Training or quality communications in general can be delivered, and that can raise user awareness within the company and highlight the risks from deviating from internal policies. I would say a lot of training I see often focuses around compliance and regulation, which is important for sure, but not always the same thing as security. Often go hand in hand, but not always. And lastly, I'd just like to highlight that logging is really important. Ideally, logs should be centralized and using a sensible timestamp. I strongly suggest UTC, particularly if you're across multiple time zones. Increasing the amount of logging in, in the log retention period may result in more useful data being available, but it can have an impact on performance. So you need to have a think about what you're collecting and how long you're going to retain that for well in advance, because much of this data is lost if it's not collected at that time, and if it's not retained for a reasonable length of time, then why are you collecting it in the first place? Where possible, logging, of course, should be monitored, but even if it's not, good logging can greatly help any subsequent investigation into the root cause of an incident.
Great, thanks.
I had two thoughts. Can I jump in just super briefly? The first is I can tell you've done this like 500 times because you were like, or like, oh God, I've seen that happen. Oh, I've seen when that happens. You're making me cringe. But you should probably write all those down because that was a bit of a masterclass. So those are ones that hopefully folks listening could take and go check with their teams. And if I was gonna, underline two little bits of it, good log sources and timing and so on. That's the stuff that makes a difference between a team knowing what happened in hours to days or weeks and months. And people always start that too late. You can't do it retrospectively. So I really want to give a shout out to that cheap to implement technical policy thing that even really big companies screw up, right? It was in a breach last week where they still aren't doing some of those things you're describing, Dave. So big underline. The other one was, and I suspect this is going to connect with what Simon says, you kind of talked about making policy human. That really matters. It's important to have a policy that covers all bases. But if it is, no offense, Simon, or you'll tell me off in a minute, but if it's legalese, so Simon understands it perfectly, but I read it and I kind of get bored, it doesn't work, right? It has to be a living, breathing document. What's one of the first things that happens in every breach ever? All the defenders start sending emails like, I told them if we didn't buy that security control, they would get breached. Like everyone starts chattering about this stuff, throwing things around, backside covering, because they haven't interpreted the ramifications of that in the policy and expose the company legally. So, you know, big underline to a couple of those points there. It was a really good advice in there. And sorry for interrupting in the middle of that, George. It just really resonated with me because I've seen that done badly. All right, I'm going to shut up again.
Not at all. Thanks. So Dave, just on that, digital forensics is your background. Can we totally discount it from the planning phase? Do we only need to consider it after the breach has happened? What are your thoughts on that?
Well, I certainly think it's important to build it into the plan. I mean, there are obvious reasons to build digital forensics into the plan. Measuring the extent of the damage, you know, determining how much data was taken, for example, or ensuring that the recovery after an incident is permanent, such as checking the backups that you're restoring from are actually clean. You're not just going back to an infected state again. More importantly, perhaps, the last thing you want to be doing right in the middle of a data breach is figuring out who your forensics partner is, how they're going to collect their data, how they share their observations with you, and figuring out who's actually going to be on your team to advise your PR people and executives. And hopefully you already know this well in advance.
Yeah,
I've seen that one too.
Should add there. Sorry to cross over you, James, but you know, something that regulators look at is whether you have good organisational measures in place, and you know, having these things set up in advance can really assist in helping show that. So that's just something to add from a legal perspective there.
And Simon, on the subject of this, from the legal perspective, what are the key mistakes that you see businesses making in the preparation stage?
Well, something that we often see is organisations creating damaging documents in the course of their BAU activities. For example, we see organisations who've suffered data breaches, you know, previously commissioning pen test reports or third-party security reviews, and then not acting upon the recommendations. And indeed, they never really intended to do so when we sometimes ask them. Or perhaps we might see what James alluded to there, but ahead of an incident, people discussing well-known security vulnerabilities or perhaps sensitive data that's at risk in their messaging systems or on widely circulated informal email chats, rather than dealing with those issues properly offline and then recording them in a more formal and less damaging way. You know, generally speaking, if there is a data breach incident, the regulator will be entitled to all directly relevant non-privileged documents that they request, and you're going to have to hand these over if you want to cooperate and not mislead them, which obviously we would strongly advise that you do take that approach. So the regulator is going to be keen on whether this incident could have been prevented, previous security outcomes, and knowledge of vulnerabilities. They're all likely to be asked for. So trying to avoid documenting those things in non-privileged documents is really important. So yeah, you know, absolutely, unless it's necessary or unavoidable, don't write these things down, because if you do have a breach, that's going to come back, and it may come back to haunt you.
And again, I'm going to say it again because I said it with David. I think it's right with Simon. Practice it regularly. Writing it in a policy document, doing it once a year, when it comes to your moment of truth, those behaviors won't be embedded. You have to repeat it. You have to practice it. And that's what makes the difference between a team that stops the bleeding quickly and adheres to the behaviors and one that accidentally hangs themselves with the regulator or their customers. Practice.
Thanks both. So in summary, this is mistake number one, folks, and that's simply put, treating your incident response plan as a paperwork exercise or a tick box exercise and not taking the practical steps to prepare or practice. Okay, so moving on, I think we'll have poll question number 2 coming up, and then just a reminder, we've had some great questions come through already any further questions, please do submit them in the chat box and we will get round them at the end of this discussion. Okay, so moving on, during an incident. Now, Simon, I'll come back to you again. If we imagine that a breach or a cyber attack has happened and the business is now in the very stressful position of trying to manage the incident. You mentioned legal privilege earlier. What do businesses most need to be aware of, and what mistakes can be made in that panic or simply through lack of knowledge?
Yes, so something to always think about when managing a breach incident is how you can best keep your internal findings and decisioning in regard to the incident confidential to prevent unwanted disclosure of it. The best way to try and protect confidential documents of this sort is to involve legal counsel immediately. And you should do so on the basis that they should be helping advise you with whether there are any GDPR notification obligations engaged or any other legal and regulatory requirements which are perhaps slightly broader than this, and they can also provide presentational advice to you in relation to regulatory inquiries and notifications and so on. Now, in principle, confidential communications relating to all of those things can be properly covered by legal advice privilege. And therefore they can be protected from disclosure requests to regulators, and if there's any subsequent civil litigation disclosure orders, it can also be protected from those. Just in terms of the practicalities to assert legal advice privilege, you need to have instructed a lawyer. Documents have to be confidential in nature, and it applies to the communications between you as the client and your lawyer. Now, this can be an in-house lawyer or it can be an external lawyer. Thinking about, once you've established privilege, how to prevent inadvertent waiver is something that's important as well when you're dealing with an incident, because obviously you'll be talking to others within the business about it. Top tip is to clearly define who your client is within your organization and to document this. So actually allocate someone as the client or a particular group of individuals. Make sure you mark any documents as privileged, put that in the header, put that in the title, make it abundantly clear. And if you are going to disseminate them around your organization, then please make sure that you say expressly that disclosure is not waiving privilege. Disclosing legal advice you receive in relation to an incident to your board, perhaps that wouldn't cause a loss of privilege as long as that document remains confidential. But what I would say is be careful with informal discussions around the legal advice that you receive, and things like practicalities of what it means to your business. Something else that we have seen happen is members of various teams taking legal advice out of the legal advice document, extracting parts of it, placing it into other documents which are non-privileged, and then circulating that around. That then obviously waives the privilege. That should be avoided at all costs. I've mentioned legal advice privilege there. I should just cover off actually that there is litigation privilege as well, which may apply in the aftermath of an incident, and that's wider than legal advice privilege. But I would say, as a word of warning, there are lots of considerations around litigation privilege and potential challenges, because for that to apply, litigation must be reasonably contemplated. And when you've just had an incident at that very early point in time when you're creating documents, there is some doubt around that, and there are various cases. I'm not going to go into those now, but there are considerations there. So top advice is legal advice privilege, stronger chance. Go with that in the first instance, make sure the relevant conditions are met. And then obviously you've got litigation privilege as well, which you may be able to fall back on.
And Simon, if I just to add a 20-second thought, sorry, Giorgia, I'm completely breaking your agenda, but you know that's fun, right? You know, one of the things that all made perfect sense to me, and I've very much seen that, you know, violated. I've seen people take out excerpts of breaches for the board deck under the premise of broad confidentiality, but of course confidentiality in the commercial sense and legal protections are not the same. The other kind of dimension for me is teams rushing to learn how to work together often will bring together legal and DPO teams with technical teams in the midst of a breach. And a lot of what you're describing can offer protections to the technical work, not just the legal, if it's structured the right way. And very often you have this kind of lane of doing it right over here in the legal sense. Then you have the tech folks who are like, we've got to stop the bleeding, we've got to communicate with customers, we've got to, you know, solve the problem. And they end up very non-cohesive, and you seem to have this kind of legal track and technical, and one can completely undermine the other in terms of protections and discoverability. So this is an area more and more you really have got to get tech and legal not just on the same call, but understanding they're working on the same thing and thinking about the same markings and the same update structure together. And that's not always easy because a lot of lawyers don't speak tech and a lot of tech folks don't speak legal, but that really matters. I've seen that go horribly sideways in a few breaches to really highlight what you're saying there.
Yeah, absolutely. And it's that point around the documents being produced for the purposes of obtaining legal advice. That's what James is getting at there. So that's something to think about, and how you manage that is really important in a breach scenario.
Noted. Okay, thanks both. So Dave, coming back to you, and I'm aware that you've got law enforcement in your background. Are there some hidden tips and insights you can provide for the folks listening here today who are undergoing a breach or have had an incident?
Sure. I mean, the chain of custody, for example, or the continuity of evidence, that's really important because it's easy to question the integrity of any evidence which doesn't have a direct line back to the source. Any material that's generated or relied upon in a court or any other legal proceeding should have solid and verifiable continuity. It's important to have someone conducting the work that understands that, or there is a real risk that otherwise good evidence can be tarnished. Now, I was a police officer for 15 years, and I'd just say that I've seen a wide variety of police responses from good to not so good. As for specific examples, I've seen multiple cases where our only chance of, say, for example, defeating an encrypted disk was to take a copy of the data whilst it was turned on and decrypted. Unfortunately, the computer was turned off and thrown into a bag, and that's resulted in the only opportunity of getting a decrypted copy of that data on the disk or the decryption key from RAM. And that's gone now, and it's possible that evidence of a serious crime's been lost. Often, it's preferable for all parties involved, including the police, should they be involved, for your network administrators or incident responders to perform certain actions and hand data over to the police, or even conduct the technical investigation themselves if they have the capability. This is because in many situations, the police just don't have the capability to deal with much more than what is called dead box forensics or mobile phone extractions. There are, of course, exceptions to this. That's quite a generalization, but it's true much of the time. I've also seen companies report incidents to the police months after they've occurred with no data preservation in place. That's resulted in data being overwritten and the police left with nothing to capture. That's actually more common than you think, because the temptation is just to recover from the incident straight away. And if digital forensics is an afterthought, much or all the evidence might be gone, and therefore digital forensics could be very difficult or impossible to implement. Of course, I'm no lawyer, so as always, seek legal advice where appropriate, as there are obviously legal obligations as well on reporting to certain parties.
She said, call Simon.
Simon, do you have any thoughts on that, or should we move on?
I mean, yeah, you obviously need to be aware of your notification obligations and make sure that you meet those. But no other thoughts at this stage.
Great. Okay, James, I'll come to you. Now, considering that the overall management of the incident if a business is trying to contain a breach, what are the key things that they should and should not be doing?
Yeah. So our last poll question actually contributes to this. I mean, you can see the intellectual honesty of our audience, and also why this stuff is hard, right? If breaches were a question of just technology and controls, sure, they wouldn't be infallible, but it would be a much tamer issue. This brings together organizational understanding, policies, communication, people working together, and it's in the gaps of all that complexity that things go really wrong. And in that last poll result, we had 36% of folks saying, are my team trained and practiced enough? And 43% saying, hey, I'm worried about communication to clients and stakeholders. And some other bits and pieces too, but those two kind of mass areas, yeah, you're right to be concerned. Breaches are really dynamic. The tone of the security community and journalists can swing on a sixpence so quickly, and getting the balance right of velocity and timeliness and enough information for a business is really tough. You need the right advisors, you need the right practice, as I've said, and practice makes perfect. Many of us will remember, Dido Harding turning up from Talk to do an interview on television about the breach, and she kind of sat there for 20 minutes and tried her best, but it was very obvious she knew nothing. Her team sent her out to talk about this breach with, well, less than no comment. And it was assassination. It was kind of complete confidence undermining for folks. We've also seen people flip the other way of oversharing details and then being wrong and having to walk back. Now, if I'm going to pick a lane, moving towards suitable transparency and communication is better than attempting to be deceptive and hiding things. From the regulatory perspective, from the customer perspective, commercially, now that frankly a lot of people are disillusioned to data breaches from a customer impact perspective, never thought that's something I'd be positive about. But it does come back to what our audience are saying. You need to practice this stuff. Tabletops sound contrived. They sound irritating to organize. They're hard to moderate unless you're good at it, but they work. I've been in so many organizations where we pull together a scenario, we bring together the team, people learn what their role is. Executives learn through that process. They really don't know a lot and can't make authoritative decisions without correct out briefings from their team. Technologists involved learn through that process that they're often really bad at explaining difficult concepts to business people under pressure who are after answers. I think that one of the biggest takeaways to be ready here, aside from picking up best practice guides and going through Dave's wonderful checklist, really is get a tabletop scheduled, get help running something that practices the communication and brings the team together, not just the tech folks, the lawyers, leadership, comms and marketing. Right size that to your maturity. Don't expect perfection the first time through, and do it with some regularity. People forget, people change, roles shift. And one last little detail I add here, an extra benefit of it, aside from it helping you to find your tone of voice in a breach and know what's going to matter and how to apply Dave's checklist, Simon gave you a big clue earlier on all the stuff when it comes to the regulators. And there's this concept of reasonableness. You don't have to be perfect. Breaches are going to happen. You can be the best security organization in the world and get breached. Doing an exercise and practicing with your team to show you're going to be responsible when something bad happens. You're going to manage that customer data the best you can. You're going to be ready to work with the regulator. That buys you a lot in the balance of demonstration later that you're reasonably prepared and that you're a victim as opposed to negligent. So I think my point here is exactly what the audience is highlighting, what they're struggling with, And the answer is good practice in advance. And if you don't know how to do it, get help, get someone like Dave to come and put you through your paces and point out all the things you did horribly wrong. And if it's the first time you've ever done one, expect a grade D-. It will be horrible, but start and work on improving. I really sound impassioned on this practice thing today, but I mean, if I think of the hundreds of breaches I've been involved in, it's the single best piece of advice I really can give.
Thanks, James. And you've basically done my job for me summarising this. We've had some really key mistakes drawn out from that phase of discussion. So summarising, and this will reflect what's on your handouts. Mistake number 2 is coming out as the increasing regulatory and legal risk through inadvertently waiving legal privilege or by creating new potentially damaging documents which are not covered by privilege. Mistake number 3, not considering digital forensics as part of your response and mistakenly losing this key evidence. Mistake number 4, not considering strategy for these communications or notifications to the public of the incident and subsequent complaints handling. A really key point there that can leave scars or a halo on your reputation. Okay, so I think we're just about to go to poll question number 3. And again, folks, just a reminder, the panel is here. We'll have a decent amount of time afterwards to answer your questions. So please do submit any further questions in the chat box. Okay, so we've done before an incident, we've done during, now moving on to after an incident. And Simon, I'm going to come back to you because one of the key things that we always associate with incidents is the ICO. And I know that a lot of businesses will want clarity on this. So what are the common pitfalls that you've seen and that businesses regularly make when reporting to the ICO?
So things that we see quite a lot are over-disclosure, inconsistent handling of regulatory notifications. So not just your notification to the ICO, but perhaps you may have an obligation to notify the FCA if you're a financial services organisation, or the DPC might be engaged because the EU is brought into scope. Predetermining matters is something that we see quite a lot as well. So people trying to second guess what caused the breach before that's been determined. Things we've seen have included, DPOs, CISOs, others in the organisation making unnecessary admissions to regulators like the ICO through voluntarily sharing information that wasn't requested by them, such as just providing the full incident response report up front, or not, as I say, providing the same information to different regulators, or inconsistent accounts over time. So telling the FCA one thing, or providing them with a particular document that you have in your notification and then saying something else entirely to the ICO, or not updating them together as your investigations progress. Word of warning, MOUs are in place between most of the regulatory authorities, certainly within the UK. They may well correspond with each other in relation to the breach, and they also may ask you for copies of the information you've disclosed to the other regulators. Something that we often see is a regulator saying, have you notified any other regulatory authorities? And then the follow-up question is, well, what have you said to them? So be prepared for that. Build it into your overall strategy when you're handling the incident. You can really put yourself on the back foot early. So think about all of this up front. It's safe to assume data protection regulators are going to be most interested in it if it's a data breach incident. So think about them as the primary focus. I said this earlier, be cooperative, provide what's necessary to the regulators, but do not start telling them about irrelevant, unrelated, historic breach incidents, or making unnecessary admissions based on your own determination of how you think perhaps security controls operated, without first having the proper forensic specialist and also legal consultation up front. And this goes back to what James said, have a joined up, dedicated team in place from the outset. and that really helps with all of this.
Got it. Thanks, Simon. I know there'll be a lot of security folks listening as well that their ears will prick up to that. So that's super helpful. And I'm just thinking, Dave, coming to you, this is where you come into your own. This is where the digital forensics team arrive, and you'll do your investigation and provide a report. How can businesses make sure that digital forensics process is handled efficiently? And is it just a report? Can we maximize the benefits from it? Wanting some further information on that from your perspective.
Sure. Well, to give the digital forensics process the best chance, if you like, the details should be known and specified in the plan, and the team should be notified, instructed as soon as possible, because usually there are exceptions, but usually evidence will erode with time. So whilst the recovery from an incident is often the priority, without an investigation, there's a danger that the same or similar thing that's happened the first time can happen again. Now, to prevent that, training, security improvements and so forth can be implemented, and the basis for those can come from a personalized debrief, if you like, after the incident, or just taking the report itself, depending on the needs of the organization. During the engagement, good communications needed for a number of reasons. I mean, this is to ensure that, firstly, the incident response team have the resources they need, such as getting the assistance of a system administrator, but also to ensure that the person instructing the incident response team is kept updated, so other departments, their PR, their legal and so forth, can operate effectively and do their job during the incident as well. I would add as well, all too often, civil and criminal cases are not considered. I mean, this is fair enough in some circumstances where there's little chance of catching the culprit, if you like. But say, for example, if you have a rogue employee that causes a loss to a company through some kind of fraud, sometimes no consideration is given to potential criminal proceedings in that case. I mean, I can recall one example where a company in Merseyside suffered a loss as a result of a disgruntled employee, and they basically heavily discounted items on for sale on their website. A report prepared, evidence and chief provided to the courts, and that's resulted in a conviction for fraud by abuse of position. And some of the money was actually reclaimed by the court for the company by means of a compensation order. So there's also a possibility of civil remedy as well. But for either route, my point is you're very likely going to need a good forensics report and an expert witness for that.
And I may add there that the rogue employee consideration is something to think about in that scenario if it's engaged, because the ICO and other data protection regulators are going to be looking at whether you had appropriate technical and organizational measures in place. And sometimes if there's a rogue insider who's acting outside the course of their employment, there's not a lot you can do about it. You can have the best systems in place, and it's just unavoidable. So it's worth thinking about from a regulatory perspective to put forward that as a defence if it's apparent.
I think you've got to think about the broader organization as well, right? In the same line that Simon's talking about, I've seen this go sideways where things are considered from a technical perspective, and the whole HR, employee policy, fair handling of folks thing is missed, and you can end up with invalid investigations or unfair treatment. So you've got to think about kind of business engagement as well as what Simon's describing, and making sure you have the right representation and processes. And you don't want that driven without a HR person helping you to navigate those specific requirements.
Thanks, James. And I'm going to come back to you. Finally, to sort of high level this a little bit more, what are the key mistakes that you've seen being made in the aftermath of a breach, and any takeaway key pieces of advice that you'd like to share?
Yeah, for sure. So there's one big one. And this will sound ludicrous. Some folks who are listening will probably go, oh, I've seen that. Others that have yet to experience a breach at their organization, fantastic, this will probably happen. You go through this process of a breach, and people are taking notes, they're paying attention to what they did. Often the pace of record keeping, note taking, and reflection is significantly outpaced by the panic to try to get the work done. And I always tell teams, if you're going too fast to write notes, then you're ultimately going too fast overall, because that means you're not capturing lessons that you ought to be. The kind of second problem is, once you've captured the set of things you should have done differently, you've been reflective on how the attacker breached you, you've made your notifications, there's a follow-on issue of businesses talk about applying those things and don't. If I had £1 for every time I've seen an organization be breached by issue X, identify the requirement for Y, and then be re-breached with exactly the same mistake within months, oh, I'd be a rich man. I know that sounds nonsensical and baffling. Like, how could anyone go through something so stressful, so high priority in the business, and then not apply the changes? But it happens time and time again. People revert to norms from before. So you really need this review body. You really need to make sure that you have the output of this breach process, the good, the bad, and the ugly. And you need an executive or someone suitably authoritative to do review point meetings at 2 weeks, at a month, at 3 months, and make sure the organizational and technical measures are applied. And I'm pretty sure Simon would cringe at the prospect of having a document that says what's wrong with processes or controls having been breached, to be breached with the same root cause once more. That's not going to be a fun discussion. So do your follow-up and make sure you have a structure to actually apply those changes and learn those lessons. It happens more often than you'd think.
Thanks, James. So in summary, mistake number 5, not performing in-depth analysis after a breach or making proactive changes to prevent it from happening again. Okay, so we've got poll question number 4 coming up, folks. And then we will give you a couple of moments and we will get into answering some audience questions that we've received. Okay, so first of all, question for Dave. We've had, what would your take on a reasonable time be? We've seen dwell times decreasing with ransomware attacks, but it's a tricky thing to define, especially when justifying to the board why you need X months of retention in the SIEM. Dave, are you happy to handle that?
Sure, yeah. I mean, the answer is it really does depend on the business size and the scale of what's reasonable. With increasing retention times comes, increasing costs of the storage of this. Yes, logging can be quite expensive, depending on what you're logging and the data sizes involved. So it is hard to say. However, if you're looking at things shorter than a couple of months, then you're starting to get into the realms of it's getting less and less useful. So it's a hard one to answer. It does depend for each organisation, but I would like, not always what's possible, but I would like the 3 months and up, really. But yeah, it depends on each organisation. Yeah, sorry if that's skirting around the answer, but it really does depend for each organisation. But yeah, anything a couple of months or less is quite low. I'd want a little bit more than that personally, but if that's what you've got, that's what you've got, I think.
Thanks,
Cost
Dave.
and reasonableness, right? This stuff can get expensive, so you have to factor that in.
Sure.
Okay, moving on to the second question. Question 2 for Simon. What is the most common mistake you see in relation to initial data breach notifications being made to the ICO?
I'd say something that we see a lot of is organisations prematurely assessing the risk of harm caused to individuals and committing too early on to a position with regard to Article 34 communications under the GDPR. And I can understand why this happens. It's because the ICO's initial notification form tries to force your hand on this point. You know, it's true that you must notify individuals without undue delay, but this does allow for a period of analysis to determine if there's a likely high risk of harm. So if you need time to do this, to assess the data and assess who might be affected and impacts, make sure you do that. Don't just commit to a position with the regulator, but do so expeditiously and make sure you can justify why you need that time. But it's something we see so often as people saying, yes, we are going to notify individuals, and then lo and behold, they analyze the data and they change their view on that. So just make sure you do the analysis up front.
Thanks, Simon. Okay, question number 3 we've just had, and I'll for equal sake, I'll send it to your way, James. And the question is, my experience with customers is that they often get the reports, pen tests and advice in, and it gets lost because they don't organise the remediation. Is that common, or am I simply working with odd sorts?
No, it is common, sadly, and I'm sorry to hear that. That's a stressful thing. It's stressful for technical folks to have issues they want to remediate and be unable to for whatever specific flavor of organizational issue is causing that. And on the legal management or data side, it's stressful knowing such a document exists, burning a hole in a desk somewhere, waiting to be used for blame. A couple of thoughts on it. The first is, often those reports in our industry are misaligned to what they could be to help a business be better. I read a lot of pen test reports that do kind of secondary reviews and assessments for teams. And a lot of pen test reports celebrate a victory around finding some high severity issue. They don't do a good job of explaining what was done well. They don't do a good job of aligning to frameworks for improvement. And the mitigations are often some version of be better. Sure, there's a link to a technical article about that specific bug, but it doesn't get back to, here are the changes you need in your culture, or here are the changes you need in your development team's practices or your software procurement. They don't work on business outcomes. Pen testing and similar reports have become a bit of a race to the bottom in the industry. How fast can we make them? How automated? How margin rich? When their original point was to help businesses be more secure by emulating adversaries suitably and then helping improve it. And they've become a celebration of, I did you over. So that's an important thing to change. And you got to get the right pen testing approach, the right reports, because it makes them more actionable and it makes it more likely a team can focus on changing the thing that matters. Anyone who gets a 20-page report of medium severity to high severity stuff will initially panic, pick 3, and then get busy. The second thing you can do, there's great utility and power to having a security council and picking metrics that drive the organizational behavior you're after. So if you if you have a systematic problem of mitigation issues, a failure to patch, a failure to kind of remediate those reports, getting together a council where you can put the light of day on that, right? So I think the age-old expression is sunlight is the best disinfectant, can be hugely powerful, but you need to bring pragmatism to it as well. People often kind of bang the desk and expect security folks to just fix everything and make it better. They're often under-resourced, under-able to execute this stuff. Use that council as a means to prioritize, pick the things that you're going to do first, and as you know, Simon would no doubt back me up, receiving a bad news report isn't an instruction for perfection. You don't have to do everything in it. You have limited resources, limited investment. Pick together the things that matter the most as a team, focus on the things that expose the most customer data, that have regulatory risk, or that could be most damaging to the business, and help the security folks direct or expand their resources. It's really hard to give you a silver bullet answer. It's a lot easier when you're in an organization and can see the specific issues and can coach on that. I do a lot of the kind of I'll be CISO for the day type things. But that's some advice for you. Get in the discussion and help prioritize and keep those things in mind. It's not a mandate for perfection. I hope that helps a little bit, and you're not alone.
Definitely not. Thank you, James. So we're coming up to time, folks. So I'm going to ask the panelists for their one main takeaway point. If there's nothing else that we leave with from the chat today, what are the key things that you'd want to share with the audience? And I'll start with you, Simon, then go Dave, then finish up with James.
I'd say get your ducks in a row now before a breach incident happens. This means don't think that you will not be a victim of a data breach incident. You probably will be at some point. Think about whether a document that you're creating will see the light of day before you create it. Do not say damaging things in non-privileged documents if you can avoid it. Get legal involved immediately if there is a breach incident, and assert legal privilege where possible. And be clear about how privilege is going to work in the course of an incident, and how the right channels and procedures can be put in place to help protect it. So those are my key takeaways.
Dave, can I come to you?
Yeah, certainly. I'm going to be quite short and just give one point, and that is, if you don't have a plan or haven't practiced it recently, now is the time to do it. And just leave it at that.
Great. James, coming back to you.
It's a variation of what the folks before us. I think we're unified. Practice, run the tabletops like David talked about. There's so much good advice flying around. Writing it in a document, putting it in a corner doesn't help. Hoping to figure it out when it goes wrong doesn't help. Practice now, figure out a version of good, and make sure your team understand their role, because it will happen to you. It isn't a question of if, it's a question of when, as the greatly contrived security saying goes. So tabletop, practice, repeat.
Thank you, James, and thank you to our panelists, all of you today. It was a fascinating discussion. Really delighted to have moderated, and thanks so much to the audience and you folks for joining us. We have a survey that will pop through, which will just take about 30 seconds. Your feedback is really important to us, so please consider filling that in. And lastly, if you have any questions from the legal perspective, then please direct those to Simon. His details will be on the handout. Anything on the cybersecurity technical front, anything you want to probe more with James and Dave, please send those through to my email address, which is also included there. On behalf of everyone, thank you so much once again. Delighted to have had this time with you and shared some really important insights, and hopefully speak again soon.